Qualified immunity is a doctrine that was created by the United States Supreme Court in 1967. The doctrine shields government officials from liability for damages claims, even if they've violated the Constitution, if they've not violated what the Supreme Court calls clearly established law.
When the Supreme Court created qualified immunity, it did so in the terms of the court to protect from liability all but the plainly incompetent or those who knowingly violate someone's rights.
There's an ongoing, vigorous debate about whether qualified immunity is important for police officers to have. The Supreme Court in the early 2000s decided a case in which they held that lower courts deciding whether an officer was entitled to qualified immunity had to do two things. One is that there needs to be a constitutional violation.
Do the actions of this officer violate a constitutional right? Yes or no? That officer may still be entitled to qualified immunity by virtue of the second inquiry, which is whether or not that right had been clearly established at the time of this now decided upon violation.
There needs to be a prior court case holding the conduct unconstitutional, sufficiently similar in factual terms to the case before the court, that the factual circumstances of that case would inform the defendant that the conduct was unconstitutional.
If the answer to that question is no, I would give that officer qualified immunity. But at least now we know moving forward, if somebody does something like this again, it has been clearly established.
The Supreme Court explained that that process would help clearly establish the law in the future and give guidance to police officers and police departments about the contours of the Constitution. In 2009, the court said that it was unnecessary for lower courts, when deciding qualified immunity motions, to answer the first question. And that decision has allowed subsequent courts and the Supreme Court regularly to grant qualified immunity, holding that the law was not clearly established, without ruling on the underlying constitutional claim, meaning that the constitutional claim regarding that case remains undefined, and it becomes increasingly hard to clearly establish the law and get past the hurdle of qualified immunity. In the courts around the country, there's a great deal of confusion about what clearly established law means. Can only the Supreme Court clearly establish the law? The Supreme Court recently said that they assumed arguendo that decisions other than those by the Supreme Court could clearly establish the law, but they've never come out and said clearly which courts can clearly establish the law.
It's important for officers to have qualified immunity so that they can perform the discretionary functions of their job without fear of liability. I have talked to many individuals who have told me that in certain situations they knew and recognized that they were entitled to use force, and they told me that one of the things that prevented them from doing so was the fear of being sued after the fact. That's a dangerous situation. Law enforcement officers must be able to do their job, including using deadly force if it's appropriate, without that fear of liability hanging over their head.
When I studied the frequency with which police officers contribute to settlements and judgments and lawsuits brought against them, I found that cities and counties that employ those officers pay more than 99% of the dollars in those cases. So the financial justification for qualified immunity as a shield against the financial burdens of litigation is simply untrue. The Supreme Court should reconsider qualified immunity doctrine because, as Justice Sotomayor has explained, it renders the protections of the Fourth Amendment hollow. When the Supreme Court grants qualified immunity to officers who shoot people without justification, who shoot people against the orders of their supervisors to stand down, it sends a message to officers and to society as a whole that officers can shoot first and think later.
Qualified immunity is not meant to put a roadblock to the courthouse for legitimate plaintiffs who have suffered a violation at the hands of law enforcement. If a law enforcement officer did nothing that constituted a knowing violation or would satisfy a plainly incompetence or almost a gross incompetence level of misconduct, that person should not, that person being the law enforcement officer, should not have to defend what he or she did in the courtroom.